Welcome back to the host Judiciary Committee this Wednesday morning, April 22nd. On S193, we're going to have probably a fairly brief walkthrough because there haven't been that many changes in 2.1 from 1.1, but wanted to be official and have Eric walk us through those changes. 2.1, 2.1, yeah. Section 1 through 3. Yeah, that's the only place where we've been changed. Actually, I think we've only been, changes in 1 and 3, actually. Sections 1 and 3, I believe.
Eric Fitzpatrick with the Office of Legislative Counsel. Good morning, everybody. Here to talk, with the committee about proposed revised committee amendment to S193, activating to establishing a forensic facility for certain criminal justice involved persons. I'll get to it, but there is actually one change in the rules section. It's, I think, in section 4 or 5, and requested by the Center for Kind Services, but it's consistent with some of the other proposals that we're going to run through here because it's all part of the same request from CCVS. But before we get to that, I'll note the other proposed changes to this version of the amendment. Changes are in yellow highlighting, so you can see they're noted between this proposal and the previous one that the committee looked at. So again, we're talking in section 1 about, so this is a forensic facility where it's a forensic facility. So in other words, there's people that are being committed to the facility are coming from the criminal justice system, not from the civil courts, not from the family division, from the criminal justice system. And from that criminal justice system, you've got 2 avenues where they end up there. One is folks who have been found incompetent to stand trial. And the other avenue is folks who have been found not guilty by reason of insanity, NGRI. So you got these 2 avenues. The first section, where the changes you're going to see are from Avenue 1, competency to stand trial. So this is the universe of people who've been found incompetent to stand trial. And remember, it's not everybody who's found incompetent either. Only for certain offenses, right? It has to be punishable by life imprisonment. Between 10 and 15 offenses in Vermont law carry that penalty. So it's a pretty small percentage of the number of criminal offenses. And
just a quick,
go ahead.
A quick question on that, Eric. Can you just give us a refresher of what those 10 to 15 crimes are?
Yes. Unfortunately, I was downstairs testifying on a different bill, so I left that file back in my office when I had to zip up here.
Get back to
but it's homicide, kidnapping, arson causing death, aggravated sexual assault of a child, sexual assault with extenuating circumstances, those sorts of offense. Oh, there's treason actually is in there. But it's between 10 and 15, and I do have a list, which I can, so you have it specifically in front of you.
Yeah, I think it's just helpful just because I think sometimes maybe that point gets lost in some of the lines of questioning in the testimony of like, we're not talking about the general population of inmates that are receiving mental health services. We're really talking about this very finite, small, narrow group who have committed some of the most serious crimes that, one could really imagine. So I think it's just helpful to give us a level setting the table. So thank you for that.
Yeah, definitely. Yeah, I think you're right. It's helpful because that's a specific criteria for getting sent to the facility. So it's good to know what offenses are.
Right. Yeah. Thank you.
Yep. So again, that's the universe we're talking about here. I had to have been charged with one of these lifetime offenses. And there's a really technical correction. It's the first one you see on page 1. This is something I think that Judge Zone brought up, which is the language originally had been transferred. Line 11 had been transferred to the facility. But in this case, when you're talking about the competency, folks who have been found incompetent, there's still a pending criminal charge against them. So DOC and the court still have jurisdiction over the person. So Judge Jonay's testimony was that the right terminology there would be remanded to the Commission of Corrections for placement at the facility, as opposed to being transferred, because they're not really being transferred from one entity to another. They're already within the jurisdiction of that entity. So that's the idea there.
Yeah, go ahead.
Eric, would this be the only law where somebody who has not been convicted of a crime is in the custody of the Department of Corrections Commissioner?
It's an interesting question. I mean, you could say that someone might be in DOC custody pending the resolution of their criminal case. So, for example, they might be under probation. They might be the case is going on, hasn't got to trial yet, so they're still in DOC custody. They could be charged with the violation of their conditions of probation, for example, if they violated what the court had imposed. So in a way, there's sort of an analogy there because this is a case where the similar criminal charge has been brought. It's still pending, but sort of along that sort of timeline, they were found incompetent. So the criminal case can't proceed right then. So there's an off ramp to this facility, and then that happens until they're either restored to competency, in which case they can go back down for resolution of the criminal case, or released if they're not going to be restored and they're not dangerous.
Right. And so it's going to be up to the Commissioner of Corrections to make that decision if we put this language, right?
Yes, with I think ultimately the decision is the court's. Because the court has to make the finding of they're either restored to competency or they are unrestorable and not dangerous. Those are all court findings that are required. But yes, they are based on recommendations of both DOC and the clinical services director within DOC. So procedurally then, what we're talking about, the changes here on page 2, this is, I think there was discussion in committee about the fact that, because remember, if someone comes into this process by virtue of being found incompetent to stand trial, the question then becomes, all right, well, what happens next? And there's, the proposal had been, there has to be a hearing every 6 months to determine whether or not the person is competent. They're either still competent, still incompetent, I should say, still not competent to stand trial, or perhaps they're competent because presumably, they're required to be receiving competency restoration services while they're there. So, but there was a little bit of lack of clarity about whether or not that initial stage requires a hearing. And so that's what the language you see on page 2 is. It's making clear that, all right, person gets transferred to the forensic facility because of lack of competency. And then look at line 4, every 6 months from that date of admission. So from the time they get there, that's when you count 6 months. And 6 months from that date is when there has to be this reevaluation, essentially, reevaluating competency. Clinical services director, in addition to every 6 months, there's another time that the hearing could happen. And that's when, and the reevaluation could happen. And that's when if the clinical services director ever says, hey, wait, I think this person actually is likely to be found competent now. That's another point, in addition to the every 6 months, when they have to say to the facility, hey, this person's got to be reevaluated, and it gets sent to court in that circumstance as well.
And Eric, just in terms of, I think that language is extremely helpful, and I'm glad that it's being included. I guess I'm struggling to see where, let me maybe take a step back. My understanding is that the competency evaluation would be administered by who? AHS or Department of Mental Health?
I think it's DOC and the clinical services director. The bill gives them the authority to contract with a provider. So it could be, they have some discretion. Could be well.
Okay, sure. So could be. But I guess the thing that I'm struggling with is what intervention, if any, does the Commissioner of Corrections have in this process? My understanding is that they don't have any ability to intervene, but correct me if I'm wrong.
Intervene in the sense of kind of the timing of those reevaluations?
Yeah, I think just like the general process, because the only area that I see the Commissioner of Corrections being named explicitly is on the first page in line 11. Is that they're just being remanded they're just being remanded to the custody of corrections. They're not really being remanded at the sole discretion of the Commissioner of Corrections. But again, like maybe I'm misinterpreting, but I just want to I'm just trying to double check my understanding.
Yeah, I think they have general management and oversight authority. I'm trying to look for the definition of under forensic facility. So that's way much further on the bill, page 14.
Right.
So it's the department. It's a locked facility. I'm on page 14, lines 18.
Yep.
And actually also page 50, line 12. So that they have this general establish and operate the facility sort of, so they're the one in charge. So they have that sort of authority. As far as the specifics, for example, say their participation or ability to uh, uh, be involved in these court proceedings, I think that is left unspecified. So they have this general, they run the facility. They operate, establish the facility, and they run it, but those details aren't specified in this bill at least.
So it would be reasonable and correct to interpret the language that the commissioner would oversee the managerial aspects of the facility, not they wouldn't have the discretion of saying, this person's receiving these services, this person is being incarcerated, this person is not competent. That's going to be left to the professionals in the mental health realm, right?
I view that as the clinical services director's job, which I think is also a requirement. Somewhere in here, it also says there has to be a clinical services director.
It's towards the end, if I recall. But regardless, I think that the responsibility relies on other individuals, not the commissioner of corrections.
As far as the details of that sort of treatment sort of thing,
Yeah.
I think so, yeah.
Thank you.
But again, overall authority with the commission.
Yeah.
So back to page 2, clarifying that at that 6-month period, the court has to have a hearing. So there has to be this hearing at the 6-month mark. And this is this competency evaluation hearing. They're reevaluating the person's competency. And prior to that hearing, that's also clarified line 8. Before that, these evaluations have to be supplied to the parties, which makes sense because they're going to be arguing about, or potentially arguing it, based on those evaluations about whether the person's competent to stand trial. Then so making clear lines 10 through 16, page 2, what are the options at that hearing? Court either finds that the person is competent, that's the first provision, subdivision A. When you think about it, it's sort of like a fork in the road there, right? Or at that hearing, one or two things is going to happen. The court's going to find that the person is competent now, in which case stands to reason. What makes sense? Well, then the court notifies the state's attorney and the person's attorney, because in that case, their person could be retried for the criminal offense because they're competent now. If you're at that fork of the road, the other fork in the road could be, well, what if the court finds after the hearing the person is not competent? So even after 6 months, 12 months, 18 months, whatever, it's these 6-month periods, still not competent, then the court orders continued competency restoration treatment. Again, remember back sort of that to be clear that this is not meant to be an infinite loop, because there's constitutional limitations on keeping someone there indefinitely. So if you get into that other other avenue of the fork, which is, hey, they're still not competent, so they're going to keep getting services. Remember, the person can always ask for an evaluation of whether they're restorable at all. And if the court finds that they're not and they're not dangerous, then they have to get released. So that's the idea, is that you have these provisions for release eventually, if the person's not dangerous. Short but still impactful change, bottom of page 2, lines 20 and 21. As drafted last time, this idea that any party can ask for this competency reevaluation, the 6-month competency reevaluation, to include an evaluation of whether the person's restorable or not. Under the previous draft, that could only happen at the second or subsequent evaluation. So at the 6-month one, it couldn't happen. So this one says at any evaluation. So basically, you can always ask for restorability to also be evaluated. And if that happens, then the evaluation has to include an opinion on restorability. That's existing. That isn't changed. That's still the case.
Okay.
No, Tom, please.
So an evaluation could be asked for at any time. Is that what you were saying?
Not at any time. It's every 6 months.
Okay, it's still at the 6. Okay.
Yeah. Although I should add to that, unless it's being asked for by the clinical services director. They can, if they decide, if they think that it's likely that the person has become competent, then they can ask.
So in between that 6 month
Exactly.
period, if they see
Yep.
progress or whatever. Okay.
I
I obviously didn't understand what you were saying. You were saying that the defendant could, request at any time, and then I was worried about request after request.
Yeah.
For the system.
Right, right. No, they're still on that 6-month track unless the clinical services director finds out beforehand, hey, look, looks like the person's covered.
So my question was actually very similar to the vice chair's, and not so much on timing, but on who can request it at the initial outset. So beyond the clinical services director, can for the initial competency evaluation, who can that be requested by? Or is only the clinical services director?
Still only.
Okay.
Yep, you're still on that timeline unless they make that person, that individual. Okay.
So actually, follow-up question. So on the 6-month, 12-month, 18-month timeline, at those different intervals, can anyone request, or is it automatically assumed that these evaluations?
It's automatic, yeah,
It's automatic.
by statute. Yep.
So just one other thing, and this is something to think about. I'm not asking you to do it right now, but I'll ask Dr. Bowen and others of whether the forensic facilities clinical services director in line 5 and 6 can ask for a hearing, not just because a person's likely competent, but also if they're not restorable. If they find out pretty much right off the get-go that this person's just not restorable, they shouldn't have to be waiting for the 6 months. But I'll ask witnesses to weigh in on that question. Ian.
Were we gonna take out the language around the court shall immediately notify the state's attorney and the person's counsel because they are?
We were, but then the way it's set up now is it could occur after the hearing, right? Is that
Right. So it'll issue an order. Yeah, okay.
that would probably be helping to notify people? Okay.
Okay, so moving on, next, you'll see that no other changes until page 5. And this is the point, as I was mentioning, remember the sort of forks in the road that you come to. If someone has asked for an evaluation of restorability, the court finds that they're not restorable, they then have to turn to the question of dangerousness, all right? If they're dangerous, then the person continues to receive treatment. But if the court finds they're actually not dangerous, so they're not restorable and they're not dangerous, then they have to release the person. This new language occur, and then there's existing language about conditions of release, supervision, I should say, supervise conditions of supervision when they release the person. This adds language to say, okay, at that point in time, when the court is ordering release, then the victim has a right to be heard. And this is language that was requested by the Center for Crime Victim Services. You'll see that it's both here, same language is going to be added in the NGRI, not guilty by reason of insanity proceedings as well. And then that's connected to what I mentioned, that there's some changes in the rules too. All of that were requested by Center for Crime Victim Services to have an opportunity to be heard here. And basically that says, you look at page 5, state's attorney has to provide the victim with notice of the hearing. This is the hearing where the court's going to decide on dangerousness, on releasing the person. And then they continue the hearing. They may continue the hearing. Court may continue the hearing if the victim doesn't get the notice. And then some provisions about what rights the victim has at the hearing. They have the right to be present, as well as to offer any views that they may have concerning the offense and their preferences for the person's placement in care. That's line 70 to 18. If the victim isn't present, the court asks whether the victim has expressed any other oral or written reviews about the offense or placement. The court may consider those views. So that's all new language there. Over on page 6, just a cross-reference change, an addition there to make sure that that's an accurate statement of when it is the person remains at the facility. I think that's it for the competency piece. Then if you turn down ahead to page 14, and this is what I just mentioned, this is the NGRI proceedings, this is not guilty by reason of insanity, just the same language. There had been a little bit in there already, the unhighlighted language on line 6 at 9 through 10, a little bit, it's without giving much detail about the victim's ability to present their views. So this just expands it to mirror the same language that you just looked at for competency, victim health. Same rights to get notice about a hearing and to make a statement and when they're there. So, and then I think the only other change is the rules piece that I mentioned. Yes, that's over page 18 and 19. Remember, this is the requirement that the Department of Corrections implement rules. They have to go through the rulemaking process, and there's a list of issues that have to be addressed in these rules. And this adds one issue, starts at the very bottom of page 18, victim notification procedure. So their rules have to describe how these victim notification procedures are going to work. Over on page 19, including which events within the forensic facility will trigger victim notification, who's going to provide the notification and how victims are going to be informed of their right to receive notifications, and the processes that will allow them to opt in or opt out. And those are all types of provisions that you have elsewhere in law already, but have to track or parallel it here, I should say.
Other questions for Eric? Yeah,
Just one on the victim notification. The language about the court asking if the victim is present. It's kind of different than other victim notification language. Was there a particular reason they wanted it worded like that?
That's a good question. I don't know. I mean, they proposed the language and that issue is reflected in their proposal, but if you get some testimony from, say, Jen or someone at Center for Crime Victim Services, see what they were kind of aiming for with that specific language.
so I'll just flag a question that I want you to think about, but not answer right now.
Okay. I love those kind of questions.
On page 5, and I'll ask other witnesses this. The process where somebody is now under supervision.
Yep.
Do we need to have, for constitutional reasons, a check-in, a periodic check-in on that? Because it looks like that's just set up to go into perpetuity, being subject to those orders. So that's the question I'd have you kind of think about. And maybe even if it's not constitutional, we should still think about having a check-in so that there may be a need for changing the orders, for instance, and not necessarily for ending the orders that are called for on Roman numeral 1 and 2. So that's just, but I want to also find out if it's kind of like a requirement that we I mean, I think we should do it. Question is whether we have to do it as well. That makes sense?
Yes.
Okay.
One other.
Yeah, Ian, yes.
Back on page 2, the line 4, every 6 months from the date of admission. I think I understood from one of the witnesses this morning that there's a potential where someone could be in the forensic facility and then they are found to be a person in need of treatment and put in an order of hospitalization and taken out of the forensic facility and then put back in.
That's a readmission?
Yeah, I'm kind of wondering, so would the clock start from the initial admission or would it start from the readmission? I think that the thought here is they're incompetent the whole time. The reason that they were taken out was because of their risk of harm to themselves or others for the person in need of care. Does my question make sense? I'm just wondering, is that an issue with how we're running the timeline?
I think I get the timeline piece. I'm not sure. Are you thinking about someone who ends up committed to DMH, they get moved over to the family process? Or no, you're thinking that someone who
they're under an order of hospitalization. They meet the clinical standards and now they have an order of hospitalization. So they are hospitalized. That's one of in page 1, line 22.
Yeah, right.
So they're no longer in the forensic facility. I would say it seems obvious that it would be just admission. I mean, they're readmitted.
They're readmitted, so the clock restarts.
You would think. I should have asked.
Seems to me like a question that really the court should be deciding for litigation.
No, I'm not trying to poke weird holes in this.
Right.
Yeah. Okay.
Yeah, that's right.
But it could be specific. about the clock, because same question could be about readmission. That's what I thought I heard you say. Let's say the person is found non-restorable and not dangerous, then they have to get released. But then there's that process for, they could be found, well, they're out in the community, the clinical services director could come to the conclusion that they're dangerous again, they get readmitted. What clock are they on now?
Yeah. Maybe
Again, good question for
Good
judge.
question for the court. We'll investigate it before it gets to.
I was just thinking, how could the two sides varying opinion on this complicate the timeline? One challenges competency, vice versa, Is this flexible enough if there's a challenge? And then an expert. You know what I mean?
There could be, same way, I think, probably now, right? Sometimes there are going to be different experts reaching different points of view on whether someone's competent or not.
It happens frequently.
Right.
Mostly in these type of cases.
Yeah. Yeah, I think that this does allow for that because the court has to have a hearing. Parties show up and they have a different point of view, which you say not uncommon.
But is there a clock ticking that we have at that point? Or no?
I think that yes,
Because you may have to schedule a whole nother evaluation according to the judge or something. To see what the next opinion.
I see. You're thinking like, say this hearing takes a long time. Then let's say it takes 5 months. Are you then a month later at your next 6-month period?
That's exactly what I'm thinking.
Right. Interesting question.
And that actually raises another question for the timeline for the disclosure of the competency evaluation.
Has to be disclosed prior to the hearing, you mean?
Yeah,
Right.
so if parties want to get experts to battle out at the hearing, if DOC discloses it the week before.
That's interesting that you probably would want, whether or not a court would interpret it this way as we talk about it, you probably want that 6 months to be 6 months from the finding, not 6 months from probably that's where the way the clock should.
And the date of admission would be from the finding.
Well, the first admission, I think that one's all right. 6 months from the date of admission, that first one, but after that,
It should probably be from the final.
right?
Because it could take a while.
Yeah.
Also for the court to make the determination as well.
Yeah, exactly.
Yeah.
Right.
So you will fix that.
Right. I just talked myself into a corner the other night.
Yeah, exactly.
Actually, I think it's okay.
Ken.
Eric,
Yeah.
we all know that the lawyers are gonna rip this apart with the court and all this stuff, and they're gonna work the time clock or what game clock or whatever you want to say about this. Bottom line is it's gotta be done. I mean, why is this so complicated that we're not just dealing with the situation at hand? Right? I mean, when you're going in and you're incompetent or whatever words you want to use in it, the opposing side is going to go and try to reset everything. So there's going to be some verbiage in there that just takes care of that goes in, is going to deal with that, because again, they're going to reset the clock every time. They have to be fair to the person that is found incompetent or insane or whatever the word is. Am I wrong?
No, you're right about that. So I think it's from the front end where we are sitting around this table. We can do the best we can to anticipate the circumstances, like Representative Oliver just mentioned one. When we flag one, we try and make sure the language is as solid as possible. Because yeah, challenges are always going to come. We're not going to think of everything. But yeah, that's our attempt is to craft the language with what you mentioned, knowing that, keeping that in mind, it's going to happen, but let's be as clear as we can on the front end.
Now, most of the testimony that I've heard so far we're just trying to make this so complicated, and it shouldn't be complicated. It should be common sense. And I realize that I'm dealing with politics here and not business, but we're dealing with people's lives here. And this is very important situations that needs to be dealt with. We need this facility and we need to do it as best as we can. It's not going to be perfect right out of the gate. And we're going to have to make tweaks. It's very simple. My opinion. Tell me I'm wrong.
I think that's a policy opinion.
Well, the
Oh,
policy.
here we go, Zone A.
Well, from a drafting perspective, I think you're right, except for the very simple part. There's a lot of language. That's
Well,
why.
that's because you guys are all politicians and I'm not.
I'm not a politician.
Well, I don't want to get too far off the reservation here, but
All right, so we'll move on to Dr. Bowen now, and thank you, Eric.
Yeah, sounds good.
We'll be having a version 3.1 at some point.
Yes, absolutely.
I know it'll be 18.1.
I'm gonna go single digits. We're gonna go stick single, not gonna get double digits in draft numbers.
So unless we count the 7 drafts that they had down in the Senate, then.
See what I mean?
We'll be at draft 10 overall, then, so.
Right.
All right, thank you, Eric.
But Kenny, on the
Thank you,
bright
guys.
side, the more versions there is, the closer.
Thanks.
So Dr. Bowen, if you could.
Yeah, I know what it's saying.
Oh, I just need to
All right, thank
concentrate
you.
on other
Yeah,
things.
see you soon.
Thanks, Eric.
You bet. Have a nice day. Thank you for coming back, Dr. Bowen.
Is this your tea?
It's been there for a
No,
while.
it's- Thank you.
Car is missing apparently.
Somebody's walking.
Yes.
I was here this morning.
Gotta turn it this way.
So if you could, I mean, we have some questions for you, certainly, and also if you wanted to just kind of some comments in this draft first, if you want to start with that.
Okay, for the record, Dr. Jill Bowen, Commissioner for the Department of Disabilities, Aging and Independent Living, Dale. Thank you for the opportunity to talk with you further about this. The first thing I want to say is, to your previous comment, is more versions bring you closer to perfection? I'm just checking.
You really want to go there?
I don't, but I couldn't help, but yeah. Well.
Keep working with me. It'll be great.
For a second, it's good. So I really appreciated some of the changes that were put into this next version. I think you addressed a number of areas that were unclear and you clarified them. I think the Q6 month was clearer than it had been before. And I just want to say in general, there are, I think we have discussed the gap. People, I think, recognize the gap in the system, the importance of due process and having an opportunity to see if you can get to competence, even though for developmentally disabled, there'll be many who won't be restorable. And the idea of being able to have some agency in requesting a review and the clinical services coordinator, et cetera. I also think that there are a couple of places in this process where legislators will get another look-see, right? So AHS would be working over the summer together to create the October report. And then there's the rulemaking process and likely an appropriations process. So I think that there is a flow that still has to come on the back end of this, making it through in, reasonable time. So that's.
So a few questions I think have come up. I'll start with them. So first is on page 1, line 20 and 21, where there's an order of hospitalization. If there was a commitment under Act 248, would that be an equivalent?
It should.
So that, I mean, if there's a commitment under Act 248 for an order of hospitalization, they shouldn't be going to the forensic facility.
They don't need to go to the forensic facility. They're already, the issue is you can't be in custody of both at the same time.
Right.
Right. So they
You
wouldn't.
just need to add that.
Yeah. I think you can clarify that. Now, if there's a new charge or something of that sort, there would probably be a discussion with the court.
So that was one question. The next one I had is if you wanted to weigh in on that, it's on page 2. And so if an individual is clearly not restorable, we're still waiting at least 6 months before we actually get to that point. Should the, and I'm looking at line 5 and 6 is where something like this could be added. Eric would have to work on it, but should the clinical services director be able to have the hearing earlier, not just if they're competent, but also if they're just not restorable?
Yeah, I think that's a good idea. I think for people with developmental disabilities, they're not a monolith. And for some, I think a good clinical services director that has, the knowledge and experience should be able to identify that possibility sooner.
Right, okay.
Right.
So we're not holding somebody where we know they're not restorable.
Mhm.
And the last question I had, and then the other folks have questions.
Can I just add to that there are folks with developmental disabilities who have never attained competence in their lives, right? So we call it, is it attainable? For some it will be, but for others it won't. And so that's appreciated. That question's appreciated.
So last is we have for supervision, I'm just I think it's the same on competency as well as not guilty by reason of insanity. I'm looking specifically at page 5. That those orders that are put in place, we don't have a check-in, and this is the question I asked Eric, is whether there's a constitutional vulnerability. If we don't, that's kind of one question, but even if there's not that, should we have a periodic check-in to see if the prescribed regimen of medical, psychiatric, or psychological care should be changed? I mean, it seems we should write that in to here.
Yeah, I think so. I mean, I think that would be helpful to ensure that it's not that someone's not long in there longer than they need to be, right? I think anywhere where there's a cycle for the person to be able to request or for the parties to be able to request is good. But I think the check-in being baked in is useful.
Right, there's always some concern about high request if it's like keeps on requesting every week.
Yeah, no, it has to obviously, yeah, right. Of course, it has to be on a reasonable cycle, but I don't want to take that out of it as it goes. If it ends up being that the person is determined to be non-restorable, but is still dangerous, that's the place where you could end up spending more time, and good to have a check-in there.
Those are questions I had. Other questions? Yeah, Barbara.
So I've been trying to just look at New York a little bit more since you were in, and it looks like in New York, the Department of Mental Health is the organization, is the department that runs the forensic facility in partnership with corrections.
In Manhattan, yeah, and so the state office of mental health does, but there's also local facilities because there's 2 different levels.
Right, okay. And it looks like that is the trend. I know that's not our lane and our committee, but I was curious because it looks like more states are having mental health run it in partnership with corrections.
So some states do through corrections and some states do it through mental health and some states do it as a collaborative.
So when Susan testified this morning, we were talking about like an outside independent sort of monitoring entity, just as checks and balances. And I know that if it's considered a forensic hospital, there could be the Joint Commission that comes in and does accreditation. So I'm just wondering your thoughts on who and how would be the accrediting organization.
So I think you're going down a path that's a little premature right now. And I think we really do need to have that time to put a report together and to really think about things like rulemaking and where AHS is going to ultimately have, responsibility and all. Once you start getting into, is it a hospital? Because I don't think that's what we're talking about
I just
here.
want to make sure we don't forget about, like, like, it seems like a bottom line for me is there has to be some accrediting,
Talking about oversight.
right, and standards, because if the commissioner of corrections is where folks are getting into, or whatever word we're using there, they oversee the well path contract. They could back, they might have pressures to cut back, and it might be services are cut back, or like it just seems like it could be too murky if there's not, again, like a licensing. Like, I have always run programs where the licensor comes in. There's, the goal of not only meeting licensing standards, but looking at like what is the accreditation, that is possible, and how do we.
So I truly understand that, appreciate that. The state's Department of Licensing and Protection is under me. So I definitely understand what you're saying. I do think that we're ahead of rulemaking in this conversation. Oversight and responsibility and quality assurance will all be discussed with the levels of details that you're talking about. Again, AHS is the agency that's going to be, the one. It's not corrections either by itself or solely that is going to have that level of.
Right. So in some ways, if they were remanded to the Secretary of AHS, I'd feel like, okay, that person has everything at their disposal. Where it feels like if it's I feel like we're already in a rabbit hole if it's.
So I don't necessarily have a concern with that. I have less of a concern than you do, but I have no concern with what you just said because of the way in which in Vermont we operate as a senior and executive leadership team.
And I know you're sort of new to Vermont, and
What's today's date? I think it might be 2 years.
Wow. Okay. I mean, because again, I've had the privilege of working with a lot of AHS secretaries as long as I've lived here and worked in human services. And it's varied quite a bit. So I just, would want to make sure that it wasn't at the philosophy of whoever was in, and there's nothing embedded in the law that.
I appreciate that. I think that there will be opportunities in rulemaking to really get into that kind of weeds. And, we're going to be working over, assuming this does make it through, we are going to be working over the summer to prepare for that report that would come before you. So there's places for that that I don't think are, I think it's a little bit premature because we don't have this base to work off of yet. But your thought about AHS is perfectly reasonable one in general. I think to make sure that we understand that what this is talking about is not a hospital. Make sure, right?
But it's not a prison.
It's a secure facility. I've talked about like what's within there as opposed to the out. Once you walk in, is it therapeutic? It's really about the provider, and whether that will be WellPath or not is not also set in stone, right? What is happening in that space? A lot of it will depend on the provider who's engaging in these activities with the individual to help them, achieve, if possible, the ability to have due process, because we don't know whether they're guilty or not of that charge, right? And the second piece of it is risk and risk mitigation, and whether that can happen to a point as quickly as possible for the person to be able to be released.
Any other questions? Yeah, sir. Nice to see you again, Doctor.
Same here.
Really appreciate your testimony. I think one of the things, maybe taking a step back, is I think, not your testimony per se, but one of the ideas that's being conflated is that this isn't a mental health facility, this isn't a prison, this isn't a hospital, it's some kind of combination of the three. And to your point, it is clearly defined as a secure facility, and that's what this facility is. I also, think that the decades of experience that you bring to the table is extremely invaluable to us, whether it was done here in Vermont or on a much larger scale in New York State or in Pennsylvania. So I really appreciate the lessons learned that you're bringing to the table on this. One of the things I want to double click on is talking about the collaborative approach that you and the executive leadership team is taking across the agencies. And I was wondering if you can just kind of speak to that, because I think, individuals keep bringing up this point of whether it's a commissioner or an agency acting unilaterally. And I don't think that's a reasonable expectation or concern. So I was wondering if you can just kind of speak to the collaborative nature.
Yeah, we did a lot of work to get to a point where we really wear two hats as commissioners. We're also the part of the executive leadership team. We work very closely together. We've met as a group several times in talking about what this opportunity is. It's not just folks with mental illness that this is speaking about. This is a very small population, just to put a mark on that, because of the narrow requirement that, right? So we're really talking about people who have been charged with a very small number of possible charges that could lead to a life sentence. We talk a lot about that, and that is narrow. And the number of people who would actually be in a facility like that is small. So we've been talking about so many factors, and that's why when I say a report will come from us all, in October. And just the way in which we operate now, we have, for the agency, we all participate together in what the priorities are. We all work together on how that's operationalized. So we're not siloed. We obviously all have services and populations that we focus on, but we have the same goals, the same priorities, and we make decisions together. So it's very different. Even I have to say, from when I first arrived 2 years ago to where we are today, it was a real intentional effort to get us to where we are today. It's quite different. When AHS presented the budget this year, we all came because it was all of ours. We were all in the room together, and that was important. And then we each did our own budget pieces of it, but it was important to show that there's something very different that's happening at AHS. And that is helpful in a scenario like this. It's really helpful because we all recognize that we bring different expertise and are representing different populations. But the way we really think about it is that the people may move into different areas of service, but they're all ours. On any given day, they could have a criminal justice intercept. Another day, they're in a mental health facility. And another day, if it's a developmental disability, maybe they are in Act 248 or wherever. But they're all our clients, right? We serve all of those folks, which also includes the public. And so we take the risk very seriously there as well. But we do that as an entity.
Thank you for that. And I think those points to me are very well taken, because I do think that it's kind of, opening up the curtain a little bit to show, the leadership and the skill set that all of you bring to the table, and that this is a very collaborative approach. There's a couple of things that I just kind of want to put a pin in as well. WellPath has been talked about ad nauseum, and I don't know if you were here in the room when I was talking about this, but my concerns about people demonizing them as a private equity conglomerate. And, I dug into the financials. I leveraged my experience in New York. We hadn't talked about this. I know that you're also a New Yorker, but I lived and worked in Manhattan at the New York Stock Exchange. So I think there's a lot to inform what WellPath actually is as an entity, and as a recapitalization, et cetera. Anyways, being the one that oversees licensing in the state, everyone at WellPath who be interacting with these clients and with this facility would be a licensed individual.
So, and OPR would regulate that, right? So again, there's an entity, and I tend to think I'm in my mind, I'm still a clinician in some ways, right? So, I always take with me the experiences of working with individuals. It's so much a part of who the actual provider is and what their skill set is. Sure, credentials are very important, that they have the experience and the training. Less concerned about the entity that they're part of and that they bring to the actual individual that needs these services or supports or treatment, should it be. So I think that's where the key is here. Whether it's WellPath or not is less clear at this point. You know, I don't think that anybody is wedded. Again, we need to go through these other steps that would happen after this was made clear. But ensuring that whoever it is that's brought to this particular table is has what they need to have to be able to engage appropriately and provide the level of evidence-informed assessment and the training and the intervention to make that difference, to give them the best chance that they have to get due process and to get risk mitigation. Because at the end of the day, if a person is competent, they're like everybody has then the opportunity to get defended. And if it's not attainable, then they should have every opportunity to have risk mitigation so that they can return to the community. So it's really the provider piece of it is really about where that experience and skill lie.
Thank you. And the two things that I keep coming back to is not only are they qualified to be doing the work that they're doing in Vermont, but the second thing is that they're great partners. And, we have heard consistently from the Department of Mental Health and from the Department of Corrections, we have nothing but reviews for the work that WellPath has done on behalf of the state and the agencies. So I think, part of my own personal frustration, we've heard that testimony. And one of my concerns is when people bring up individual ad hoc reports from other states, we have no idea what the circumstances around those reports or those states choosing to disengage with WellPath as a partner, really the underlying causes of that. The last thing I want to bring up is, you have worked at such a much larger scale than what we have here in Vermont. And I think one of the things that we keep hearing is cross-state collaboration between New York and New Hampshire seems like a reasonable comparison given scope and size. And even that is a little bit, their population is
So much.
double ours.
Yep.
So there really isn't a fair comparison. But when you look at New York State and the state system and the local system, we simply don't have the infrastructure to create a parallel system here in the state of Vermont. So I'm wondering if you can talk about the complexities and the intricacies of that dichotomy between Vermont operating in the market that we're in and New York's trying to draw a comparison and a parallel to New York State, which is a totally different animal entirely.
So I would say, look, Vermont has this gap. This gap has been identified. You fill that gap, you'll see that in New York, there are so many options, right? Because it's so much bigger and there are so many different levels. Like I say, there's forensic facilities in which I worked that were local, run by the city operated, whether it's a city hospital or city corrections and how that intersected with NYPD and all of that was an entity unto itself. And then you had your state level, right? You also had state hospitalization there, which you don't really have here, right? It's a little different, right? You had your state hospitals, you had your city hospitals, and there were places where there were criminal overlap with mental health or other entities, right? But there's also a flow, right? Where you have the ability to move through different levels. Vermont has, so many fewer people and so many fewer, setups that you're going to have to work within what Vermont's situation is. You're not going to suddenly have a flow. You can have some level of a flow, and I think you're trying to build that in here. I do see it here that there is a flow, but you have when you identify a gap, you have to kind of fix it for Vermonters, right? You have to fix it right here. It's not going to be something I think that can come out in to kind of fix it. You can learn from what other places have done. But I think it can be a little apples and oranges when you're talking about these massive scales or these these things that have built up over like long periods of time and have dealt with the challenges to the system and had to make course corrections. They're still making course corrections. I mean, there's still plenty of improvement that can be done and is constantly being worked on. There have been different medical providers, medical, psychiatric, and other providers that have come into the public prison system or jail system, because there's both, in New York. And some of them were really good, and some of them weren't. There have been efforts to provide direct services from within. Some of that turned out okay, and some of that didn't. So it's not necessarily about whether they're private, public, it's really about how does it work in that system, and to make sure that people are getting the services that they need.
Thank you. Very helpful.
Thank you very much for testimony. I really appreciate it. And when we have the next version, we'll give you the opportunity, if you wish, to weigh in on.
Oh, yeah, no, I appreciate that. Thank you.
We'll have that sometime.
This was left on the desk, so I'm gonna leave that there.
All right, so we'll hear from Matt Valerio next. Please join us, Matt. And if you don't get through the testimonies, we can have you back certainly as well, Matt. In fact, it's probably going to be another version of this anyway, but.
Perfection.
Yeah. Yeah. No, that doesn't happen here very often, I'm afraid. Perfection.
More noodling, that's all.
Yeah, noodling, thank you. Yeah.
I'm not familiar, I'm Defender General. I do wonder first if there are any specific questions you might have for me about this, or anything particular you want me to comment on.
It's really, I mean, yeah, there's one area and really this committee is primarily section 1 through 3, and that's where these various changes on the draft. So the draft 2.1 should have been sent to you yesterday, I believe. And the one question that came up this morning is with respect to, and then would like your general comments on this as well, is with respect to the supervision if an individual is found not restorable, but also not a danger and is being supervised by, well, right now it's Department of Corrections. We'll see where that lands. And whether right now there's not a check-in as far as, there's the order and there's not like an end date on these orders. Is that a constitutional issue? I think even without the Constitution, even if it is not a constitutional issue, I think it's just good practice that there needs to be check-ins.
Well, there does have to be review constitutionally as to whether the order should be maintained. As you know, I testified before, and I think with what I'm seeing with these new versions is, and I appreciate the fact that some of the suggestions that I've made have been incorporated into this. I've long said, number one, of course, that we need a forensic facility. Number two, that we need affirmative supervision of individuals who are on orders of non-hospitalization. So I see that that's in there, and that's good, as you're talking about. To me, the issue that arises is whether you want the Department of Corrections that comes at issues like probation and parole from a different mindset than somebody who would be a social worker or who is mentally health trained in a mental health field, looking at these individuals from a treatment perspective if they are relieved. My experience over 40 years of dealing with corrections in various states and here is that corrections is about compliance as opposed to treatment. And so when they look at somebody who's not doing something that's on the list, to them that's a violation. A social worker or somebody who looks at it might look at it and say, oh, what is the what do we need to do to bring that person into a place where they are appropriately treated, as opposed to like the hammer, which ends up being the case in probation and parole and furlough cases. I've long said that I have a concern about the Department of Corrections being the folks who are running this. And so that's like an overarching thing, but I think the structure is right. I just think you have the wrong people supervising, if it's the Department of Corrections, supervising those orders when they're out. Clearly, to me, there does have to be review. And one of the things I was going to ask about is, it's interesting that when we are trying to restore somebody to competence, we're doing reviews every 6 months. When we're looking at whether somebody can get out, it ends up being like a year, 3 years, 5 years. If you remember that part in the bill, and to me, there should be at least an annual review of an individual, not every 3 years, not every 5 years, and
That's a not guilty by reason of insanity section.
correct, and on the not guilty by reason of insanity section. The thing about that is, I can go through like line by line this stuff if you want me to, but conceptually, if you have reached a point in your mental health treatment where you are able to be released, you should be able to bring that case on a more regular basis, and the review should be more frequent. Now, this area in general is one in other states, and at times in Vermont with particular individuals. We just don't have very many of them, right? But it is subject to, they don't have a strong advocacy constituency, and it's been subject to abuse in other states. And we are now kind of rebuilding this capacity from brick one, because our other bricks got washed away a few years ago. So if we're going to try to build it, let's see if we can build it right from the beginning, as opposed to cutting corners or building something that might be subject to abuse. It makes me nervous when they say, well, we'll deal with that in rulemaking. That kind of scares me. I don't know how many of you folks have gotten into the details of rulemaking and the like, short of review committees that the legislature has. But once it's effectively delegated to an agency with political appointees, the rules are going to reflect that philosophy at that time. Sometimes that's good. Sometimes it's not good. Depends on what side of the fence you're sitting on any particular issue. But if there's something that you want to control as a legislature, then now's the time to do it, not waiting for rulemaking. And you aren't going to be able to get into the details of every single thing that is going to happen. You don't have the expertise to do that. However, if there are overarching issues about how often reviews should be had, what are the standards for review, those sorts of things, that is something the legislature should do. Now, I might not agree with what you do, but at least it is elected people making those decisions. And, for better or worse, we'll see how that comes out. At least I know that, the input is you're going to get input from all these folks, you'll get input from me, you'll talk to each other. Rulemaking is essential because it's done by experts who are going to get into the weeds. But it also, it's out of your hands at that point. So if there's something important you want done, do it. I am going through this was kind of concerned when we were talking about, and I'm on page 2, about the court holds a hearing for the competency evaluation, blah, blah, blah. It seems to sort of, to me, the whole thing sort of skips over the people who aren't mentally ill, the ones who are developmentally disabled, the ones who have traumatic brain injury, the ones who have other mental defects, so to speak, that would make them not amenable to competency restoration. And to me, that again is a smaller group, but it is also a group that is not, to me, the type of group that a forensic facility per se should be focused on. Because if the forensic facilities, it looks like one of the main reasons for the forensic facility is for competency restoration. Those two groups are not usually amenable to competency restoration. They should go to a different line.
Right, so question on that. So for when there's a competency evaluation that is done, is it traditionally part of such an evaluation to determine if somebody is restorable, if they're restorable to competency, or can that be part of the?
It absolutely can be. And I've seen those that say, this person has a traumatic brain injury. They cannot participate with your, in their defense. They're not, and it's not going to heal. We can't train them or do something to them that's going to make them competent to be under the jurisdiction of the criminal court.
So this is a small population, life
for sure.
Sentence. So presumably right off the bat, when they're asking for a competency determination, that could be part of the request. Because what I'm thinking is, and I keep on moving this back, if there's somebody clearly not restorable, they probably shouldn't be going, what I'm hearing from you, they shouldn't be going to the forensic facility at all because they're not restorable. And so perhaps even, something to consider is on page 2, line 1.
Yeah.
That has one of the criteria for putting somebody in the forensic facility is that they've been found not competent to stand trial and they are restorable, or something along those lines. I mean, that's
Not likely to be restored to competence.
not likely to be restored.
I guess anything is possible at some point, but yes, I think.
But there's still the issue of where is an individual if they are dangerous and they're not restorable. Where do they go next?
Yeah.
In Act 48, we have that answer, but not for traumatic brain injury or dementia.
Right, and those are, this is part of the gap. It's a relatively small part of the gap, but we do see those. I think we should be compassionate about what we are doing with those folks, particularly housing them in a secure forensic facility that is really designed for competence restoration, not for the management of that personnel, because they're going to be difficult. And, I have bad feelings about having it under the Department of Corrections and that particular personnel those particular persons, because the instinct is to lock them up somewhere because they can't be managed by those personnel. Now, we haven't had a facility that deals with those in so many years now that, we've had Dale, we've had other places where people can be placed. It's just trying to avoid the possibility of abuse on the front end if we can do it.
Right. Zach,
I may have missed this in your earlier testimony, Matt, but I'm wondering if it isn't DOC, what's the alternative?
I think it's the Department of Mental Health or the Department of Health.
So I guess what I come back to is DMH, saying that they just don't have either the ability uh, or or the bandwidth to be able to oversee this facility. So I guess what would you say to that?
Can you give them the ability and bandwidth to oversee the facility? Can we, we had one before. Can we fund it? Can we staff it? We don't now, but it's a small population. Can we create a small facility and staff it without it being under the Department of Corrections? I'm asking the question. That's the way I would look at it. Now, I know that's going to be expensive because all of these forensic facilities are expensive. I mean, if you look at like cost per person, it's a lot of money.
Yeah, I think like to me, I'm less concerned with the cost. I think the cost is really de minimis in terms of the positive impact that it could have for the public safety crisis in the state of Vermont. And what I keep coming back to is number one, to your point, very small population. But number two, when we look at this population in particular, they're being charged with some of the most serious crimes that, bless you, that you can be charged with. So it's just, that's the thing that I keep trying to reconcile is this is not a normal population of either mental health patients or even prisoners for that matter. I mean, these are all individuals that have been charged with crimes that could result in life behind bars. So that's really like the push and pull. And like we hear this one department saying, we cannot be part of this. We don't have the ability, we don't have the skill set, we don't have the bandwidth. And to your point, sure, like we can write a check and compel them to do something via legislation and statute, but it doesn't really seem like that's the best approach when we have the Department of Corrections, which says we have the ability, we have the skill set, we have the staff to do this.
I remain skeptical regarding the Department of Corrections, only given my experience with what they do now. It's fine I will respectfully disagree, but this is not the best, have not been the best population to deal with in the Department of Corrections. I know that we have a disagreement on that.
Yeah, no, we do. And from our last conversation, and certainly given that your lived experience in dealing with the DOC and your experience there, and again, like I want to dig in the data with you and the anecdotes and the experience that you shared last time. And I know that you said you have your binder of cases. So, but I know that we diverge on that point, but that's the thing that I'm thinking through as I'm sitting here is we have an agency that's able and willing and has the skill and talent to do it. And we have one that does not.
Well, I think mental health has the ability to deal with it. They really just don't want to.
Well, then I think you need to go and give them a pep talk because I don't think they believe that they can.
I've just seen this over a long period of time. We had a hospital where these folks would be, and between Dale and the Department of Mental Health, they did operate it, and it worked reasonably well. It's not like everything is perfect, of course, because nothing's perfect. And then we didn't, and so since then, we've been kind of in this holding pattern, which is totally unacceptable. I mean, I think we all agree.
Yeah.
Where we are now is not acceptable. I guess that's probably where we just diverge.
Well, but I do want to double click on the point of agreement that we have is that the need for this facility is 100% evident. And so,
Oh yeah,
and so
there's no question
that's
about it.
where I think, well, maybe with few exceptions, but the majority of us are all in agreement is that the need is very much present.
Yeah, and I'm happy after many years, honestly, that this proactive supervision of people on orders of hospitalization or non-hospitalization is something that's like on the table and actually being discussed. And again, devil's in the details of who's going to supervise it and what the training and mentality of the people who are doing that work is going to be. But to me, it's for the safety of the individual, the person who's subject to the order, as well as the public and their ability to get treatment ongoing so they can remain safe and productive in the community. I'll tell you my experience with many of these cases when I was actually handling them was that the people who are in the community under those orders, they want to be productive. They don't want to go off the rails. And sometimes they need help to do that. That's how I see these supervisors, these people who are, affirmatively looking at these orders of non-hospitalization and making sure people are complying. That's how I see their role. If it's a matter of, when you're violating a portion of it, but, immediately locking them up again, that's not really the way I'm looking at it. But, because actually the people who were subject to them actually would prefer to be compliant. They have trouble doing that sometimes. Some people have trouble doing it all the time. But that's the very, very difficult population. So, what else can I tell you about?
So Ian has quite last question, Ian, and then we'll have you back when we're gonna have another group next week. So, and if there's.
I don't mind. I wish actually in some ways that I had my own bandwidth to be able to sit here every day and listen to every witness. And I do, but I can't. And I do have folks who on occasion will watch and give me reports. But it's, it's not like it was a few years ago.
Just very briefly. So I kind of realized that like when I was looking at this, that I sort of skipped over the sort of competency determination that starts this. So looking at that statute, which I think is the 48-1-4, they don't really align, if I understand. So for example, the court can order additional subsequent evaluations by the Department of Mental Health after a determination of competency is found that they're not competent. So, and then on top of that, there are other, we're talking about trying to build like the right procedure for the every 6 months subsequent evaluations on competency. There's like stuff in here around like evidentiary components and things like that. Do we need to shore these up?
I mean, ideally you would want to, because this is what happened,
Yeah.
when we're litigating this stuff, we can litigate at cross purposes, but when each entity that is litigating is pointing to things that support what they're saying, but in different parts of the statute, that becomes problematic because they don't align.
Because I guess like I could see this, you need to show a change of circumstance, but theoretically you could have a competency evaluation being ordered by the court, by the Department of Mental Health, and also every 6 months by the Department of Corrections, who competing. And then the other thing I'm realizing too is that the initial competency evaluation is going to be done by the Department of Mental Health based on this. And then the subsequent ones will be done by the Department of Corrections.
Yeah, and the thing about competency for people who are like, we're really talking about the mentally ill folks, not the folks who would be in the smaller group. Right. That competency can wax and wane over time. It's not like a static thing. It's like, oh, now they're competent, let's bring them in. And then, we get to trial 4 months later and now they aren't competent. I mean, one of the things we see when people are put in a hospital setting is they recover. They say, oh, now they're competent. Now they go into the correction, they get moved back to corrections. They decompensate. Now they're not competent again. And so we end up, defense will also be asking for these competency evaluations. Either we're asking the court to do another one or we're doing them on our own. It's just not a static thing. And so that's just the problem with these cases in general. That doesn't have anything to do with the law on either side. I mean,
Consult with Eric, and it's like
one of the cases that is going through appeals and the like, I think there might be a U.S. Supreme Court petition, the Garung case. That guy was in and out of competency for years over a period of time. So I had a horrible case, but that's what happens with folks who have those illnesses, you know?
Thank you.
Yeah.
All right, well, thank you very much. And like I say, you'll see our next version, hopefully. Well,
Why?
we'll have our,
Just a-
we'll have, maybe this committee's work on section 1 to 3 will be the penultimate. Say, but we're